So, in my research for a different video, right, where like I was gonna write some stuff out about like the fall of like our society and these type of things, I was trying to take it from the point of where it was like, hey, look, I've already been in a society that has fallen, right? In the end of the day, and so I was looking for like some numbers to back up some of the things that I was talking about, things of this nature. Doing my basic research. Because usually for like every video I do like 2 or 3 hours worth of research. Just getting numbers and these type of things so I can, be like correct in what I say. Because I don't like spouting nonsense. You know what I mean? I like, this is a pro-truth channel. You know what I mean? At the end of the day. So but in my research, I found this article, and I was like, "Oh man, listen, like, yo, this is better than anything I could have written." Like, I'll be honest, like, yo, because like this is just like how do you put it? This is like like a correlation of all the things that they found about like child support back in 2016. This is from Prison News, Prison Legal News, a Human Rights Defense Center. Right, this is fucking fascinating. So we're gonna get into this, and this is amazing. All right, so it says, poor parents fail to pay child support, go to jail. Child support is an enormous issue in the United States. In August 2015, Mark Greenberg, the Akron Assistant Secretary of the Administration for Children and Families, a division of the U.S. Department of Health and Human Services, wrote that 1 in 4 children nationwide had an active child support case. Court-ordered child support obligations totaled $32.9 billion in 2013, according to the U.S. Census Bureau. Not including past due payments, undue child support is estimated at $113 billion nationally. Further, child support is an issue that mainly impacts the poor. Based on 2013 data, 76% of parents who owed past due child support earned $10,000 or less per year, while another 9% earned between $10,000 and $20,000. The poverty rate of custodial parents who received child support payments was 28.8%. So let's get this right? So the people who owe past due child support debt, right, are poorer than the people who they owe it to. It's awesome. It's great. Billing poor fathers doesn't help poor mothers, and kids become less poor, observed Jacqueline Bogues at the Center for Family Protection, Family Policy and Practice. Instead, it results in a highly indebted individual who can also result in parents being jailed for non-payment of their child support obligations. The practice of incarcerating mostly poor parents for failing to pay child support is well over a century old. In 1910, the National Conference of Commissions on Uniform State Laws approved the National Uniform Desertion and Non-Support Act, which imposed criminal penalties on fathers who failed or refused to financially support their children. This was an early attempt to improve improve enforcement of child support orders, though it did not extend to parents who moved to another state. The National Conference attempted to remedy that loophole in 1950 by approving the Uniform Reciprocal Enforcement of Support Act, which provided for civil or criminal enforcement of out-of-jurisdiction child support orders. Yet the Act's commentary noted that returning child support delinquents to their home state would be of limited value. If convicted, he would be placed in jail, and the state would still have the burden of support of the destitute family. Even when free again, he would be under heavy handicap of a man with a criminal record in finding a job and supporting his family. However, the commissioners finally decided to leave criminal enforcement in the Act because it was a traditional method of solving the problem. It was not certain that civil enforcement would take care of all the cases. And it was felt that while actual extradition would be of little use, the threat of extradition might be a powerful weapon in the case of shiftless and slippery child support obligors. Right. The Act's commentary succinctly stated the problem. Incarceration is the nuclear option of child support enforcement. The threat of going to jail might be useful in persuading reluctant parents to pay child support, but actually doing so does not achieve the desired result, payment, and is fraught with negative consequences. If one only considers the substantial cost of incarceration, it becomes a very expensive option for enforcing child support orders. Nonetheless, according to one estimate, 50,000 people are incarcerated in U.S. prisons and jails for non-support of child support. I've actually found numbers that are as high as 440,000. Right? If you look at it in the real aspects, it's 48% of all people in jail have a child support case, right? So I mean, technically, 48% of the entire fucking prison and jail population of the United States, right? That's 440,000 human beings. Parents who are truly destitute go to, and 1 in 7 children have a parent who's in jail. Parents who are truly destitute go to jail over and over again for child support simply because they're poor, added Sarah Garrity, an attorney with the Southern Center for Human Rights, who represented the class of Georgia prisoners who were jailed for non-payment of child support without legal representation. We see many cases in which a person is released, they're given 3 months to pay a large amount of money, and then if they can't do that, they're tossed right back into county jail. Even when parents want to pay, the amount set by the court may be more than they can afford. A 2009 study of the Urban Institute, a nonpartisan Washington, D.C. think tank, found that half of child support debtors in California had no reported income in the previous 2 years, and the median net income of those reporting any income was $2,881. One of my former clients worked at Piggly Wiggly Supermarket, and they were taking 65% of her paycheck. Garrity started. I left her in a position where she was simply no way she could survive on the amount she had left. Some critics had compared the situation to the infamous debtors' prisons that were supposedly outlawed in the 1880s, which have recently faced increased scrutiny and legal challenges. I try very carefully not to exaggerate, but I do think it's an apt comparison. Garrity said of debtors' prisons, I think anyone who went down and watched one of those proceedings would agree with me. You see a room full of indigent parents. The hearings only take 15 seconds. The judge asks, do you have any money to pay? The person pleads. The judge says, okay, you're going to jail. The Federal Child Support Enforcement, the Federal Child Support Enforcement (CSE) program was designed into law in 1975 as PL 93-647, titled 4D of the Social Security Act. Yes, they take this out of Social Security. It was intended to help strengthen families by securing financial support for children from non-custodial parents, with the additional goal of keeping some families off public assistance. Thank you, Bill Clinton. Non-custodial parents, right? Actually, this wasn't him. That was Nixon. And Nixon, right? Yeah, it was Nixon. Non-custodial parents are overwhelmingly men. Less than 18% of custodial parents are fathers. Although the states administer their own child support enforcement programs, the federal government helps to fund, evaluate, monitor, and support them. Federal officials also provide technical assistance and assistance in locating non-custodial parents and collecting child support payments. The initial approach of the CSE program was welfare cost recovery. More recently, it has adopted a family-first philosophy, giving families who are no longer receiving financial assistance first claim on current child support payments. Under the CSE program, a variety of collection methods are available to state agencies, including deductions from parents' income, intercepting state and federal tax refunds, lottery winnings, and unemployment compensation, filing liens against properties, seizing assets, including public and private retirement and financial institution accounts, suspending driver's licenses, professional sports and recreational licenses, requesting that the federal government revoke and deny and restrict passports, reporting child support obligations to credit bureaus, initiating civil and criminal contempt proceedings, and filing criminal charges. All 50 states have passed statutes criminalizing failure to pay child support, though some have decided to treat non-support as a civil matter. Failure to obey a court order both can result in imprisonment, but the latter approach leaves a non-custodial parent without a criminal record. The federal CSE statute required the states to adopt the Uniform Interstate Family Support Act and expand full faith and credit procedures to allow for effective enforcement of child support orders across state lines. The law also added federal criminal penalties under certain circumstances. Pursuant to 18 U.S.C. 228, parents are subject to federal prosecution if they willfully fail to pay child support ordered by a court for a child who lives in another state, and the support payments have been past due for over 1 year and amount owed more is $5,000. The offense is a misdemeanor that can result up to 6 months in imprisonment. If the child support owed exceeds $10,000 or is overdue by more than 2 years, the offense is a felony that carries up to a 2-year prison sentence. It's so fucking dumb. In the fiscal year 2015, the budget for CSE and family support programs was just over $4 billion. And almost $30 billion in child support payments was paid to custodial parents. Vicky Turetsky, commissioner of the Office of Child Support Enforcement, wrote that CSE had provided services to 16 million children. The state CSE programs also involved large numbers of children and huge sums of money. Florida's CSE program collected $1.52 billion, the vast majority through payroll deductions, for almost 1 million children. In fiscal year 2014, while the Washington State CSE program collected $677.8 million for 734,194 children in fiscal year 2015. A non-custodial parent's failure to pay court-ordered child support often forces the custodial parent to apply for temporary assistance for needy families, a federal program administered through the states for financial help. In order to receive assistance through programs like TANF and Medicaid, the custodial parent is required to provide identifying information for the child's other parents. Once this happens, a non-custodial parent is required to reimburse TANF for the financial aid provided in lieu of child support. In 2013, $30 billion in child support was owed by non-custodial parents to state and federal governments for TANF reimbursement. TANF debt changes the equation. No longer is it the custodial parent who is seeking to enforce a child support order. The government now has an interest in being paid, and the government attorney prosecutes non-custodial parents who owe TANF reimbursements, whether they are represented by counsel or not. When a child support payment for TANF reimbursement is made, it is kept by the government rather than being sent to the custodial parent. Further, unpaid TANF debt accrues interest, often at high rates, up to 12% annually, depending on the state, and cannot be discharged in bankruptcy. Enforcement options. Income withholding is by far the most effective tool for child support enforcement. In over 2014, over 70% of the $28 billion in child support payments collected by CSE was obtained by income withholding through payroll deductions. The remainder was obtained by intercepting federal and state income tax returns and seizing unemployment compensation. Among other methods, it is estimated that less 2% of child support payments were associated with the threat of incarceration. I mean, you want to be technical. Like, all of it's through the threat. The only way you're interacting with the government is through threat of incarceration. However, many of the strategies for child support enforcement, I mean, like, it's not like they go, hey, man, listen, like, yo, you should work with us. Be a patriot, right? Your dad's, fuck you. Like, yo, you're not taking mom. Like, yo, I am not going to give you money, right? Like, yo, because I want to be a patriot. Like, it's like saying, hey, you know, paying your taxes as a patriot. No, all right? You will never get me to come out of my pockets to support this government. Are you out of your fucking mind? However, many of the strategies for child support enforcement break down when a non-custodial parent is poor and unemployed. For income withholding or income tax for refund interception of work, the non-custodial parent must have a job. For liens to be effective, property must be owned. A person who cannot afford a car may not think about having their driver's license suspended. One may be too poor to have money in the bank. Thus, the financial assets can't be seized. So what happens to a poor parent who can't afford to pay? Although general protocol is followed under CSE program, individual caseworkers have discretion over how to manage a case, including the determination of which child support collection method to use. If a caseworker decides that an appropriate amount of time is spent trying to get a non-custodial parent to pay outstanding child support, they usually have an authority to request the issuance of a warrant to bring that parent before a judge. Sometimes caseworkers use subpoenas instead of warrants. This illustrates the main difference between poor and non-poor custodial parents who owe child support. There are more ways to enforce child support orders for parents who aren't impoverished, as indicated by the options listed above. For poor parents, particularly those who are unemployed or work minimum wage jobs and thus can't afford to meet their child support obligation, enforcement options are limited and threats of being jailed or actual incarceration is more likely. In effect, poor non-custodial parents are at a greater risk of going to jail simply because they are poor, which illustrates how poverty is increasingly being criminalized. The people we see in jail are not wealthy deadbeat dead, said Garrity with the Southern Center for Human Rights. They are often working people who have lost jobs and become indigent. A judge has several ways to deal with a non-custodial parent who owns child support, and the common approach is to hold a civil contempt hearing. This may happen when a person refuses to obey a court order, especially in the purpose of contempt penalty is for the benefit of the private party, such as the custodial parent. Contempt hearings do not require that the non-custodial parent receive the same level of due process as a criminal defendant, such as the presumption of innocence. The job of the judge in a civil contempt you know you have to presume it's like yo man, listen, our court system is fucked, son. The job of the judge in a civil contempt hearing is to separate the people who won't pay from those who can't pay. Yet the non-custodial parent may bear the burden of proving their inability to pay. It requires more than simple testimony. Documentation showing income and attempts at finding employment must be presented in court. Thus, civil contempt can become a trap for the poor and poorly educated who have little knowledge of what is required of them in a civil contempt hearing. And even though being held in civil contempt can result in a jail term for non-payment of child support, there is no right to an attorney. Of course, poor parents who are unable to pay child support are also unlikely to be able to afford an attorney to represent them in contempt hearing. In the seminal case of Turner v. Rogers, the U.S. Supreme Court held 14th Amendment does not automatically require the state to provide counsel for indigent parents facing possible incarceration in civil contempt proceedings for non-payment child support. In particular, that clause does not require that counsel be provided where the opposing parent or other custodian is not represented by counsel, and the state provides alternative procedural safeguards equivalent to adequate notice of the importance of the ability to pay, a fair opportunity to present and to dispute relevant information, express court findings as to the supporting parent's ability to comply with the court order, the court wrote. The case involved a South Carolina court who requiring Michael D. Turner to pay over $200 a month in child support. He failed to make the payments, was held in contempt 5 times. The 5th time, he served a 6-month jail sentence, which caused his past due child support to grow over $5,700. When he failed to appear for a court hearing after his release from jail, the court sentenced him to 12 months without first determining whether he had the ability to pay his child support debt. While there is no right to an attorney in civil contempt hearings, the Supreme Court held that procedural safeguards are necessary to reduce the risk of an erroneous deprivation of liberty. These safeguards include notice to the defendant that his ability to pay is a critical issue of the contempt proceedings, the use of a form or equivalent to elicit relevant financial information from him, an opportunity at the hearing for the defendant to respond to statements and questions about his financial status, an express finding by the court that the defendant has the ability to pay. The court held that Turner's incarcerated violated his due process rights as he had received neither counsel nor the benefit of alternative procedures. Like those we have described, he did not receive clear notice that his ability to pay would constitute the critical question in his civil contempt hearing. On July 11, 2014, Supreme Court of Georgia extended the holding in Turner to find no automatic right to counsel even when the state is the opposing party. The government is represented by counsel and incarceration can result. The court affirmed the decertification of class indigent and incarcerated child support debtors who were not represented by counsel at their civil contempt hearing, which were initiated by the Division of Child Support of Georgia Department of Human Services. And so, in other words, right, they said, even though the state has an attorney, you don't have to have one. Because, it's a civil thing, man. Even though you're going to go to fucking jail. You're so dumb. How are they so dumb? Whether any particular parent is entitled to a lawyer at government expense depends on whether we think the particular and unique circumstances of the case, including the complexity of the case, as well as the extent to which alternative measures might be employed to ensure that the procedure is fundamentally fair. State Supreme Court has stated, we conclude that there is no absolute inflexibility, categorical right to appointed counsel in such proceedings as a matter of due process, even when represented by its own lawyers, pursues the incarceration of another human being. It says indigent parent. Let's be honest here. Another human being, right? Legit. This is an adult fucking citizen of the United States. You're not entitled to a fucking lawyer, you piece of shit. Fuck you. Pay me. Right, women's rights are more important than the Constitution. Keeping this 100, bro. This is what it is, right? Literally, this broad, the state is representing her. Because if this was a real fucking thing, if this was how it's supposed to work, she would have to represent herself, right? And then he would have to represent himself, and he'd be like, hey, look, man, you ain't entitled to shit because I ain't got no fucking money. Then enter a judgment against him, right? And then, he'd be like, eat a dick. What are you going to do? You going to take nothing from me? What's 50% of nothing? Nothing, right? In a dissenting opinion, one justice wrote that the lead plaintiff in the case, Randy Miller, a veteran, owed $4,000 in child support but had less than $1 in his bank account. No assets, was unemployed at the time, was held in contempt and sentenced to 4 months in jail for non-payment. I feel like it's more unfair to the kids because not only, it's not even oh man, what about the dude? Who fucking do, yo? It's about the kids, right? Like, yo, this whole shit is retarded, right? All right, because now not only the kids getting any money, nor do they even get to spend any time with their fathers once they're locked up. No shit. Like, yo, this is what I'm saying, bro. Like nobody really understands. Like, the reality is that like you shouldn't even have to have this conversation. You're a citizen, right? You're a human fucking being. Like, no one else can do this to you. Like, even the IRS can't do this. Like, real shit. Like, even the IRS and be like, bro, you owe taxes. And be like, well, I'm broke. And be like, oh, fuck. Goddamn, that sucks. Like, if the IRS comes at you, you have the right to an attorney. Like, yo, this shit is worse than the tax man. Keeping it on. And the IRS took down Capone. As opposed to civil contempt, the purpose of criminal contempt proceedings is to vindicate the authority of the court. This might occur when the defendant insults, disrespects, or interferes with the function of the court, for example, threatening a judge or jury. Criminal contempt proceeding is separate from the underlying case, and conviction results in a criminal record. Criminal contempt defendants are entitled to due process protection, such as, so literally if you go to child support jail, start throwing some shit around, act like an asshole, bro, because then you have the right to an attorney. like, it's so dumb, right? To present a defense, call a witness, have an impartial judge, and be represented by counsel. The greater complexity of a criminal contempt proceeding means it takes longer than involving civil contempt, especially since an indigency hearing may be required, as well as a jury trial. So, while some parents can and do pay their court-ordered child support to avoid being held in contempt, others can't and therefore don't end up behind bars. Incarceration and consequences. Information on the total number of people incarcerated for non-payment of child support is very limited. Many jurisdictions do not track such data, and sometimes the total number of people jailed for contempt does not include a breakdown of cases involving child support. The Record, a newspaper in Hackensack, New Jersey, reported that 1,800 parents who owed child support had been jailed or placed in electronic monitoring in 2013 in 2 counties alone. Right, the records from Gwinnett County, Georgia, indicated that 3,612 people were jailed for failure to pay child support over a 10-year period ending in 2011, which each serving an average of 127 days. Some will languish for months and not be able to come up with $8,100 or $100 to $200. I'm sorry, man. Listen, type is small. Come up with $100 to $200. Some can't pay it. Sadly, I think some do have the money but just don't want to pay. Would you sit in jail for 6 months and get them $100? Are you fucking, yo, you're so retarded. Like, yo, in 2009, Serbia South. Like, this is the fucking, like, why would you be that fucking, why would you assume that? Like, man, listen, these guys are willing to sit in jail for 6 months over $100. Are you retarded? Do you know what happens in jail? They will take your butts. They will rape you. Like, yo. Someone lingers for months. Yo, man, listen. In 2009, a survey of South Carolina's county jails found that 13.2% of jail prisoners were in prison for non-payment of child support. So 15% of the prisoners were there for fucking child support. Right, in South Carolina's being only 5 days late on child support can trigger a bench warrant for a court hearing that may end up with a non-custodial parent serving a jail sentence. Parents are sometimes jailed until they pay a purge fee towards their child support debt. Based on data compiled by Texas Attorney General's Office, Bexar County jailed 1,113 parents in fiscal year 2009 for failure to pay child support, while Dallas, Harris, Tarrant, Travis County sent a combined 631 parents to jail that year. According to a 2011 blog post by Douglas A. Galby, Ph.D., an estimated 50,000 people nationwide are in jail or prison due to non-payment of child support. Based on his analysis of data extrapolated from 4 states, South Carolina, Virginia, Indiana, and Georgia. However, he noted that available data are complex and inconsistent, even when provided from official sources and legal proceedings. And the actual number could plausibly be between 25,000 and 90,000 people. Nobody has any idea. Right? This is legitimately, like, I'm trying to tell you, like, how dangerous this goddamn law is. Like, yo, real shit. Regardless of the actual number of people serving time for non-payment of child support, these otherwise law-abiding citizens are subject to the same conditions of confinement as other prisoners. They may be strip searched, denied medical care, subjected to excessive force by guards, or even assault or raped. As I just said, the same abuses that other prisoners routinely face in the U.S. prisons and jails as regularly reported in PLN. For example, when Anthony McCoy was booked into jail in Nashville, Tennessee in 2009 for failure to pay child support, a guard ripped out a gold grill that was cemented to his teeth, resulting in dental injuries. McCoy sued and settled the case for $95,000. Two administrators at the Liberty County Jail in Texas, the warden Timothy New and Chief Security Kenneth R. Nunn, were fired in September 2012 following allegations that they had sexually assaulted a female prisoner at the privately operated facility. According to a notice of claim filed by her attorney, Brandy Nicole O'Brien said she was repeatedly subjected to assault and battery, sexual assault, deviant sexual humiliation, degradation, and intentional infliction of emotional distress. O'Brien had been jailed for failing to make child support payments. Former Los Angeles County Jail prisoner Jay Reynolds, 39, was arrested in March 1999 for an out-of-state warrant for non-payment of child support. A court ordered his release after the other state declined to extradite him, was instead returned to jail where he was brutally beaten and raped by two other prisoners. He filed suit in Los Angeles County Superior Court, and the jury awarded him $1 million on November 20th. Though all but $25,000 of the verdict was later overturned by the Court of Appeal. Didn't that bitch just get like $5 million from Trump for being raped? My man was brutally beaten and raped by two human beings. 25 grand. That's what your booty hole's worth. Right? Tom Harris picked the wrong time to be arrested in New Orleans for non-payment of child support. He was booked in the New Orleans Parish Prison on August 25, 2005 and should have been released several days later. But then Hurricane Katrina made landfall. Orleans Parish prisoners were evacuated to other facilities, and Harris was not freed until February 2016. 5 months later. And when Mario Ludovici was arrested in October and booked into the Lackawanna County Prison in Pennsylvania for unpaid child support, he was drunk, had a verbal altercation with guards over a pair of sneakers, was tackled, choked, handcuffed, and punched. Jail officials did not investigate the incident. Ludovici filed a federal lawsuit alleging excessive force and deliberate indifference, which eventually settled for $15,000. In some cases, failure to pay child support may result in a death sentence, as there are numerous examples of people who have died after being jailed for non-payment, though total numbers of such deaths are unknown because no agency collects that data. Yep. Last month, PLN... They know exactly how many motherfuckers died from firearms, don't they, baby? Last month, PLN reported that April 5, 2016, the death of Darius Robinson at a jail in Caddo County, Oklahoma. His death was ruled a homicide. He was pepper sprayed, handcuffed, and strangled by a guard who put him in a neck hold. The medical examiner found Robinson had died of asphyxiation due to manual neck compression. He was reportedly behaving erratically, but the district attorney initially refused to release surveillance video of the incident. Robinson had been arrested in 2008 in a warrant of non-payment of child support. He had 7 children. The jailers choked Darius to death, but he was killed by the justice system in Caddo County, said Bryant Terrell, the attorneys representing Robinson's family members. I love, man, I laugh because like I don't want to cry on me. Like, yo, real shit, yo, clown world, you laugh so you don't have to. In May 3rd, 2016, the family of Philip David Anderson filed a federal lawsuit over his death at the Tuscaloosa County Jail in Alabama. Anderson, a father of 4, had been jailed on contempt warrant, a child support case for missing a hearing. He reportedly screamed in pain and pleaded for medical care for a week before he was finally taken to a hospital with a massively distended abdomen. In February 2015, his death was caused by an untreated perforated ulcer. Defendants rejected or belittled Mr. Anderson's constant begging for medical attention, the lawsuit stated. His screams and excruciating agony from his serious medical condition were met with demands he keep quiet or stop faking and malingering. R&B singer Sean Levert died in Cuyahoga County Jail in Ohio in 2008 while serving a 22-month sentence for failing to pay $90,000 in outstanding child support debt. Prior to his incarceration, he had been taking Xanax and anti-anxiety medication, which judge noted and mentioned to the sheriff. However, after being booked into the jail, Levert never received his prescribed Xanax and began suffering withdrawal symptoms, talking to himself and having hallucinations. He was eventually placed in a restraint chair, and medical staff failed to provide him with medications ordered by the jail's doctors. Following Levert's death, his widow filed a federal lawsuit that settled for $4 million in June 2010. Ain't that awesome? Like, yo, ain't that the greatest thing you ever heard? Like, yo, a man dies and then the person who put his ass there settled a lawsuit for $4 million. Fucking amazing, right? He was eventually placed, Frank Crown, over 51, facing a felony charge of non-payment of child support, was held in jail in Ottawa County, Oklahoma in January 2006. He argued with his cellmate Charles Bowes, 25, who was awaiting trial on rape charges. Bowes killed Crownover by ramming his head into a wall and subsequently charged with manslaughter. The incident occurred in the jail's protective custody unit. There you go, buddy. And on July 24, 2001, Michael Deal, 54, a former police officer, was murdered by other prisoners at a county jail in Savannah, Georgia. He was strangled to death. The prisoners killed him to ensure he didn't snitch on an escape plot. He tried to make it look like suicide. The Deal had been jailed for non-payment of child support. These tragic deaths get an entirely new meaning to deadbeat parents who are jailed for not paying child support and then end up dying in custody. Just the threat or possibility of incarceration could put child support debtors at risk too. In June 2011, Thomas James Ball, a veteran, doused himself with gasoline, set himself on fire, and burned to death in front of the courthouse in Keene, New Hampshire. I'll be honest with you, I thought about the same thing. I'm going to keep I really, honest to God, like I've had that thought like 80 to 85 times. He had battled with family court services for a decade over child custody issues related to a domestic violence charge that resulted in a not guilty verdict. He lost his job in 2009, was unable to keep making child support payments, was ordered to attend a contempt hearing. That is fucking foul. Ball reportedly owed thousands in past due child support, and his ex-wife had asked the court to put him in jail. Prior to committing suicide, he filed lawsuits and participated in protests at the courthouse. To no avail, he left behind a lengthy last statement that, among other issues, described his frustration with the justice system and child support enforcement. And y'all are just now hearing about it. The ex-wife's lawyer wants me jailed for back child support. The amounts ranges from $2,200 to $3,000, according to who you ask. Not big money after being separated for over 10 years and unemployed for the last 2, but I do owe it. If I show up for court without the money, the lawyer says jail, then the judge will have to be able to take me into custody. There are really no surprises for how the system works once you know how it actually works, he wrote. More recently, Walter L. Scott, 50, was shot and killed in North Charleston, South Carolina. Police officer Michael T. Slager, as he fled from a traffic stop for a broken taillight on April 4, 2015. Slager claimed Scott, who was unnamed, had tried to grab his taser during a scuffle. He shot Scott in the back multiple times as he was fleeing. Slager then picked up his taser, dropped it near Scott's body, 15 to 20 feet away, in the apparent attempt to justify the shooting. Slager has since been indicted on murder charges and also faces federal charges for violating Scott's civil rights by killing him. Why did Scott try to run from a traffic stop? He had an outstanding warrant for failure to pay child support for his 4 children and previously had been jailed for non-payment. He had back child support and didn't want to go to jail for back child support, said Grit Stewart, an attorney representing Scott's family. Scott's death highlighted the plight that many non-custodial parents face. Years before, he was incarcerated for 15 days for non-payment, even though he claimed the state agency had misdirected a child support payment to the mother of one of his other children. By the time he was released from jail, he had lost his $35,000 a year job at a filmmaking company. In frustrations, he turned to alcohol and went through cycles of brief unemployment, during which he paid child support and unemployment, which resulted in 3 stints in jail for failure to pay. One of those times he served 5 months. Scott had participated in a parenting program called Father to Father in an effort to get back on track with his payments, but his child support debt continued to grow while he was incarcerated. At the time of his death, he owed over $18,000. I hate to see it when fathers don't pay child support, but killing someone over it, that's just mind-boggling, said Sue Berkowitz, director of the Appleseed Legal Justice Center in Columbia, South Carolina. While the above examples involve non-custodial parents who owe child support, parents who have custody of their children are not immune from imprisonment because support and custody issues are sometimes handled by courts separately. Henry Price, 56, learned this when he was arrested on April 8, 2016 in Bergen County, New Jersey, for failure to pay child support and spousal support. Although 3 of Price's 4 children live with him, 2 of whom are now adults, he was ordered to pay child support for all 4 to his ex-wife, who has custody of his youngest child in addition to spousal support. The court reportedly told Peace to sell his vehicle to pay the $3,000 in child support debt, and also ordered him to participate in work release program at the jail to earn income to apply towards his past due support. According to the Bergen record, by the end of 2013, more than more than 40 orders from Bergen County family judges incarcerating parents for non-support had been overturned, most by the New Jersey Supreme Court. Those appeals showed a systematic denial of basic due process to litigants facing incarcerations. In setting up the CSE this is flaws in the system. In setting up the CSE program, Congress intended to create a fair and efficient system to ensure that parents meet their child support obligations. Assumptions underpinning the programs are based on studies that indicated most non-custodial fathers would pay some child support, and their incomes tended to rise relatively rapidly. Within a few years after fathering a child, these assumptions work well for upper and middle class parents, but not when applied to poor parents, especially those receiving government aid. Parents on the lower end of the socioeconomic spectrum often face barriers to employment. This is due to a combination of factors, such as limited education, work skills, substance abuse addictions, criminal records, and health-related problems. Traditionally, non-custodial parents have limited and no access to welfare-type programs, such as financial assistance, employment-related services from TANF, Medicaid, food stamps, and earned income tax credit. In other words, they are required to support their children but receive none of the government benefits to which custodial parents may be eligible. With fewer employment opportunities and often little understanding of the court system, which bases child support payments on the income the court presumes the non-custodial parent could be earning rather than their actual income, poor non-custodial parents are more likely to accrue large child support debts they will never be able to pay. As a result, they are subject to a number of sanctions, including having their driver's license suspended, which makes it difficult for them to get to work if they have a job, and civil or criminal contempt and incarceration. There are many negative collateral consequences to jailing people due to unpaid child support. Notably, it locks poor non-custodial parents into a cycle of poverty, diminishes their ability to find work or better paying jobs, and makes it difficult or impossible to participate in academic classes, vocational training to expand their employment options. Sometimes other family members will pay child support for a non-custodial parent owes to keep him in jail. Thus, a child support enforcement can impact more people than just a delinquent parent. The most obvious flaw of incarcerating parents who owe child support is that when they are unable, as opposed to unwilling, to make child support payments, they are still unable to pay while behind bars. Most people cannot pay anything when in jail, and if they are unemployed prior to being in prison, they may lose their job by the time they get out, making it even harder to catch up on past due child support. If the goal of the child support program is to get support for children, parents do not do that. Parents can't do that if they're incarcerated, noted CUNY's CUNY law professor Ann Cammett, an expert on child support issue. Further, child support debt accumulates during incarceration because a parent's court-ordered child support does not stop when he is jailed unless he successfully moves for an order to modify the payments. Many prisoners do not know this. In some cases, such as Nebraska, prison officials have instructed efforts to inform prisoners how they can file motions to modify their child support orders. According to 2010 data from the Office of Child Support Enforcement, the 5.2 million parents in the U.S. who owed child support that year, approximately 662,000 were incarcerated. The vast majority of offenses unrelated to child support. Most prisoners lack the resources necessary to continue paying child support, but since their court-ordered support payments continue based on their presumed or inputted income instead of actual earnings, and because downward modifications of child support orders are difficult to obtain, prisoners often owe significant arrears and sometimes tens of thousands of dollars when they are released. This can lead to reincarceration if they fail to pay past due child support once they get out. Child support obligations can have other consequences for former prisoners too. In Tennessee, for example, parents with felony convictions who are not current on child support payments are unable to vote, although that restriction does not apply to delinquent parents without felony records. Studies report mixed findings on prisoners who are released while facing large debts. Some research has suggested that owing past due child support may help a former prisoner redefine himself and cease criminal activity in favor of responsible parenthood. Other studies indicate that significant debt provides an incentive for released prisoners not to seek employment or to work in the underground economy where income is not reported. The latter trend is stronger because cases where child support orders are out of proportion with the former prisoner's income, leaving them with little to live on after making support payments. Alternative approaches and reforms. Faced with a highly successful way to collect child support, payroll deductions, and a very unsuccessful method, incarcerations, some advocates have suggested helping parents obtain jobs so they can earn income to pay their support obligations rather than letting them sit in jail. This could be accomplished through the provision of vocational training, job placement services, or government-sponsored work programs. In Texas, judges can require a non-custodial parent of a child who receives TANF to either participate in Texas non-custodial parent choices program, a work program, to pay the child support they owe, or face incarceration. The program is funded by the Texas Workforce Commission and the Texas Attorney General's Office. If the non-custodial parent is employed surreptitiously, the work program is likely a conflict with their under-the-table source of income, forcing them to admit the employment and make payments towards the outstanding child support. If the non-custodial parent is unemployed, the program can help them secure a job, according to the Texas CSE website. On average, participating non-custodial parents made no child support payments for the 8 months prior to entering the program. They paid an average of $176 per month in the first year after the program completion, an increase of 57% compared with the control group of similar non-custodial parents not enrolled in the program. The idea for Texas non-custodial, how about we just pay for fucking, like, yo, if you want women to be free, how about we just pay for it? Just give them the fucking welfare. Like, give them the money. Why are you putting this on dads? Why is this a thing? The idea of Texas non-custodial parent choice originated in Missouri, which implemented the fathering court in 1998. The fathering court allows a non-custodial parent who is behind in child support and facing incarceration to have his prosecution deferred. The case manager develops an action plan with the parent to help him become a more responsible father. His community partners provide job training and employment while he's participating in parenting classes. When the parent completes the action plan, the prosecution is dismissed. The father in court, yo, eat a dick. Like, yo, for fuck's sake. South Carolina has received a federal grant in 2014 to fund Operation Work, which helps parents who owe child support and meet their obligations. The program includes counselors, job coaches, and other staff who enroll parents in education courses and help them gain employment skills. The child support payments are suspended while participating in the program. In Virginia, the intensive case monitoring program began as a pilot project in 4 courts in 2008 and expanded to 31 by 2016. It followed decades of intensive and unsuccessful child support enforcement efforts that include incarceration and even does public shaming through newspaper ads to display the names and photos of child support debtors and the amount they owe. The ICM program places parents who owe child support on the monitoring in jail. On monitoring instead of in jail, participation on a weekly group called Club Reinvent is mandatory. The meetings offer a combination of practical advice and tips on job hunting, counseling, and group discussion to help the men become better fathers. The ICM legitimately, like, let's become communists. Like, yo, fuck it, you know, like yo, Fridge would be proud, right? ICM program requirements include making regular child support payments regardless of the amount, and providing documented proof of seeking employment. Over 2,700 parents have participated in ICM, and about 1,000 were dropped for failing to meet the requirements. States officials have collected about $4 million through ICM. Parents who complete the program pay an average of $185 per month after graduating, compared with $75 before enrolling. At least 24 other states have established employment programs for non-custodial parents in partnership with the state and local workforce agencies. Ensuring that parents have jobs, which means child support can be collected through payroll deductions, is certainly more effective than incarcerating poor and unemployed parents who are unable to make support payments. After all, the goal is to ensure that parents pay their child support. Government agencies should provide resources and services to help them meet that goal instead of punishing or imprisoning them for non-payment. Beyond work programs, systemic reforms are needed to ensure the child support system is fair and puts the needs of the children first. Since child support is intended to benefit the child, it can reasonably be argued that forcing non-custodial parents into poverty, putting them in jail where they sometimes are abused or killed, is not in the best interest of their children. Some reforms that should be considered include basing child support orders on the non-custodial parent's actual, not presumed income, making modifications of child support orders easier when non-custodial or custodial parents' income or employment status changes, reducing or eliminating fees and interest on past due child support, and automatically suspending child support payments when a parent is incarcerated. Currently, child support orders do not have to be based on a parent's actual income. In some cases, courts can find that parents are voluntarily involuntarily unemployed and set child support orders based on the wages that the court thinks the parents should or should be earning, even if they have repeatedly applied for it and failed to find higher paying jobs. Conversely, there is no requirement for custodial parents to be employed. At a minimum, child support orders should reflect the amount that the non-custodial parents are actually able to pay. In 2012, the study by the Center for Policy Research found that parents paid a much higher amount of their child support obligations when placed on a reasonable payment schedule that they could meet, rather than facing payments that were impossible to make. Current federal guidelines allow states to take up to 65% of a parent's pre-tax income for child support, which can leave them without enough to live on and encourages non-payment. When people do have orders that they can't comply with, it doesn't motivate them to work and pay. It does the opposite, said CSE Commissioner Vicky Turetsky. Further, suspending driver's licenses and professional licenses as sanctions for failure to pay child support should be discontinued. A suspended driver's license makes it hard for parents to drive to work or look for employment, while suspending professional licenses ensures it is impossible for parents to work in their profession and thus earn income subject to their child support deductions. They're fucking retarded. Like, these people they're dumb. Like, if they don't understand anything, man, listen, they're doing bad things. We must punish them right now. That's all they know. That's their whole mental, right? They're dumb, right? It's like, because females run these fucking programs, right? It's the problem. Is females think punishment is the only way that shit gets accomplished, because like they don't understand. They don't understand basic facts, right? They don't get shit. These are government bureaucrats. They're fucking dumb, right? They're like, well, I went and did everything I was supposed to do because I was scared that I wasn't going to get punished if I didn't do it right. It would be on my permanent record, right? Like, it's not even a fucking thing, and they think it's real. Like, they're fucking so stupid. Incarceration should be a last resort, and parents who face jail time should provide legal representation if they cannot afford to hire an attorney. As with criminal cases, 2 states, Kentucky and North Carolina, have programs where parents who owe child support are placed on house arrest and electronic monitoring instead of being jailed. While electronic monitoring has its own shortcoming, it at least allows parents to keep working or looking for employment rather than sitting in a cell. More radical child support reforms include adopting a model whereby government provides guaranteed minimum child support payments to custodial parents, then collects funds from non-custodial parents based on their ability to pay. This is the model used in most European nations, which ensures that custodial parents receive child support even if the other parent is unemployed, disabled, incarcerated, or otherwise unable to make payments. It would replace the current somewhat similar practice of providing financial aid to parents who TANF, then seeking TANF reimbursements from non-custodial parents. Just, man, listen, if you guys want women to be free, give them money. Why are you bothering us? What's this have to do with us? They made a decision. Like, they're people. Women are human beings. In 2014, the Obama administration proposed a new child support enforcement regulations that would classify incarceration as an involuntary circumstance and allow imprisoned parents to have their child support payments reduced or suspended. This would prevent prisoners from being released with massive debts that put them in risk of reincarceration, though they would still need to file motions to modify their child support orders. Currently, 14 states do not allow child support modifications, even when parents are in prison or jail. It's so dumb. The regulations, which also require state agencies to inform prisoners of their ability to modify child support payments, will make sure that arrears do not accumulate endlessly while a parent is incarcerated, explained Turetsky. Jail is appropriate for someone who is actively hiding assets. It's never appropriate. Jail is never appropriate for money. All right, get the fuck out of here. You're so fucking dumb, right? Not appropriate for someone who couldn't pay the order in the first place. The proposed regulations would also change the existing rules to ensure that child support orders are based on a parent's actual income instead of inputted or presumed income, and take into account the subsistence needs of non-custodial parents. The regulation schedule could be implemented in 2017 through oppositions from some members of Congress. I am fundamentally opposed to policies that allow parents to abdicate their responsibilities, which in turn results in more families having to go on welfare, stated U.S. Senator Orrin G. Hatch. Thank God he's dead. Who chairs the Senate Finance? He might not even be dead. Senator Hatch and other federal lawmakers have introduced legislation that will prevent new child support regulations from going into effect. Regardless of what any reforms are implemented, it must be acknowledged that incarcerating parents who owe child support is especially irresponsible from an economic perspective. A 2012 study by Vera Institute of Justice found the average cost of a state prisoner was $31,286 per year. It makes little sense to imprison parents who fail to pay child support when taxpayers must bear the cost of their confinement, and when incarceration does not resolve the issue of unpaid child support, which remains unpaid while they are locked up. Rather, the cost of a prison or jail term would be better spent helping poor and unemployed parents find jobs and become more responsible fathers and mothers. Or how about you just give them the fucking money? All right, which brings me to today's motherfucking sponsor, right? Legitimately, because I got to make money, okay? Legitimately. Like, there we go. There's the thing I'm looking for, okay? And then listen, why did you just do this, right? Browser, interact. Okay, this is Brad Light. Welcome to Brad Light. It's a sponsor to today's video, legitimately, right? You guys need to go check out Brad Light. You know what I mean? Order you some lasers. Put in code Pnoid at checkout, right? Get you some batteries, man. Get you some of these little diode things right here. Man, yo, go get you a laser pointer to play with your cat. Yo, man, listen, light some shit on fire, all right? You know what the deal is, man. Listen, you can, this module thing, diode module, keyboard thing, whatchamacallit, man, with silicon chip. It plugs into stuff, all right? Legitimately, go check us out. Put in code Pnoid at the coupon at checkout. All right, get Tom Peeps paid. Also, check out my Patreon. Check out the goddamn Streamlabs. Hit these damn buttons and give me some money so I can pay my support. Bitches. Tom Peeps of Pnoid News. Y'all know the deal. Like, share, and subscribe. I'm out of here. Peace.